So Craig, is there a time when I should update my will? And is there anything that could happen that might invalidate it?
So around 2008, they brought in new provisions, amendments to the Wills Act, and it basically says that if you get married or divorced at any stage, unless you actually expressly say that you're contemplating that act in your will, or by some other evidence, that, for example, if the will is silent on the issue, and you then decide you're going to get married, or you're already married and then you get divorced, that will actually automatically revoke your will. And that's probably one of the most common situations where we've had clients saying, "Oh, I got married last week," and you go, "Oh, you better get in and sort it out because it's not in your original will now." If we usually ask clients if they're thinking about it, or if they say that they're engaged or something like that, we'll put clauses in there. A lot of the time we'll get clients coming to see us referrals from family law situations, and they haven't quite gone through the process of the divorce yet, and they want to make sure that, you know, if something happens to them between now and the time that they actually do get divorced, which could be 6 months, 12 months, depending on whether it's contested or not, or longer. I'm not a family lawyer, but you know, that the last thing you want is to have a will that says everything I own goes to my ex-wife or my ex-husband, and so those kinds of things. Other examples not related to that kind of family law context is, you know, if you're changing your assets around, because remember I was saying before how it's not necessarily what you put in your will, but what your asset structure is. So if you, for example, have a will and it says, and you go against our advice and you say, I want to give this specific parcel of land to this person and that to the other, and you've sold those items or something, then there'll be an redemption of or a failure of the clause because the property is gone now, and so those are circumstances where you'd want to update your will, like basically assets, and change it to family circumstances. And we always say to people, look, you know, if it's been 7 years or so, there's no hard and fast rule, but every couple of years just dig it out. We don't bill people for just having a check, like a check-up, just check it does exactly what it's supposed to do.
There's a measure of fluidity around it.
Yeah, exactly. It does what it's supposed to do, then don't change it, great. But if you then, you know, decide to shift all your assets into a particular asset structure, then we're going to say, well, hang on a minute, that's not necessarily going to work what you did before, you know. So that's pretty much that.
Okay, great. What might happen in the event of, say, a loved one kind of losing capacity? Is that similar in a sense to what we talked about before? So if you lose capacity and we're looking at that enduring power of attorney, exactly the same sort of thing?
So I guess it depends on what context we're looking at. So obviously we want to do the estate planning for, you know, powers of attorney, powers of guardianship to kind of guard against you know, that happening in the future and having a plan in place. But if there is no plan, I think I've briefly mentioned before about you go to the state administrative tribunal and get orders. But particularly from a will perspective, if we have a client coming to us and they say, look, I've got early onset dementia, or you know, I'm starting to get cognitive impairment, or you know, those kinds of issues are starting to come into play, then you know, that's when we usually get as much medical information as we can, doctor's information, because we might be later on asked to give an affidavit about the capacity when doing the will. And I think you asked me a while back about, you know, why wouldn't you do the will yourself? And another reason is that lawyers are able to give good evidence about the capacity of a person when in the process of making their will, and that kind of thing, and influence and kicking people out of the rooms and stuff like that. So I guess that's pretty much it in terms of estate planning with diminished capacity. I mean, another thing that you might think about as well is when we talked about who's the most appropriate executor. There's no point making someone an executor if they've got advanced dementia, or you know, they're just not going to be able to run the show. And again, having the backups in your will. So if that person doesn't have capacity and they are named, then you've got your backup executor in that situation.
Right.
And then the same thing with their assets as well. Like, do you really want to be giving someone who's in a dementia ward like large amounts of capital? Possibly not.
And what on that subject, I guess, around assets? I mean, what do you do if you've got assets sort of, spread around the world? What is...
From an estate planning perspective, we always liaise with, or at least advise our clients to get an estate planning lawyer in that jurisdiction to check over what documents we've done.
Right.
So what I always advise clients to do is we will often do a will that specifies that this particular will is only to operate in the Australian jurisdiction. It's limited in that regard and to deal with Australian assets.
Right.
And appoint a resident Australian executor, and then we do the powers of attorney and so on and so forth, powers of guardianship and then we send that bundle over to some kind of accredited estate planning specialist in the jurisdiction. I mean, most of the times I've done ones in America and in the UK, they're very, very similar. The lawyers usually email me back and say, yeah, what you've done is totally fine, but we've got some special requirements for how these things need to be signed and witnessed, so they'll just replicate the documents with different signing provisions. There are conventions for wills being accepted and signed in the same way in certain Commonwealth jurisdictions. But if you're talking about, I've had clients who've got real property in Croatia or all kinds of countries where they don't have the same laws about how they can give assets away and what you can actually give away with your will, and so I always go and tell them to go and get that sorted out over there, and they usually write back. The other issue is things like death duties and death taxes. The choice of jurisdiction and where you're actually living or domiciled might dictate that if you're an Australian resident, at the moment there are no death duties in Australia, but in the UK you've got death duties, and so I've had clients in the past where we've had to go off and get advice in that jurisdiction about what's the effect of having those substantial assets administered and over in that jurisdiction. So they can sometimes say, well, if you move your assets over to Australia and you permanently become a resident, or you're a dual resident, and we'll move it over here. And I think they've got some time limits of it's got to be moved within so many years of death, and then they'll deem that to be Australian assets, and therefore you can save hundreds of thousands of dollars on death taxes and that kind of thing. So it's pretty complicated stuff, but the bottom line is always, we'll do our job over here and then we send it off for advice. And it's about finding the right person as well. It's a bit hard for clients to just Google someone that's reputable over there. Yeah.